Okay, we are live now. Hello, everyone, and welcome to the Fieldhouse Museum's online programming for tonight. Tonight, we are very, very happy to welcome Dr. Kelly Kennington here with us today. She will be presenting on her book, In the Shadow of Dred Scott, St. Louis Freedom Suits in the Legal Culture of Slavery in Antebellum America. Kelly is going to be joining us from Auburn University, where she has been teaching since 2009 in the history department. She teaches courses in history of the South to 1877, American slavery, and American legal history, in addition to survey courses in world history and the United States history to 1877. And we're really excited tonight because earlier in the year, we had our Dred Scott panel, and we had Michael Everman join us from the St. Louis Archives, the Missouri State Archives here in St. Louis. And Dr. Kennington actually did research here in St. Louis with those archives for her book. And In the Shadow of Dred Scott takes a look at cases of enslaved men and women and children who sued for freedom in St. Louis. Here, Dr. Kennington uses these legal suits for freedom to trace the broader legal culture of St. Louis and to argue for the importance of enslaved people's participation in that legal culture. So I hope everyone is just as excited as I am as I turn this over to Dr. Kennington.
Hi, thank you. Okay, I'm going to share my screen. Maybe. I'm going to try this. Okay. Nicole, can you see that okay?
Yes, I can see it.
Okay, great. Just wanted to make sure. So first off, I wanted to say thank you to Nicole for inviting me to talk to you all this evening. And thanks to Kara for helping with the technical aspects of all of this. Hopefully I've got Zoom down, I think maybe by now. I've been doing some online teaching. And so I wanted to start, and also, of course, thank you to you all for tuning in this evening. I have no idea, I can't see my audience, so this is a little different than my usual talks, but I do appreciate you joining me. And so I wanted to start by talking a little bit about how I came to this project, what interested me in studying the freedom suits in St. Louis. And so really my interest in this project developed when I was in college. So I went to Tulane as an undergraduate, and I knew I wanted to major in history, but I thought I wanted to go to law school. I've always been very interested in the law. And then I got into some of my history classes, and I got really interested in the studying history and didn't really want to stop doing that. I took a course on slavery and freedom in the antebellum South, where we read Solomon Northup's narrative that you see on your screen now, that was recently made into a feature film, an Oscar-winning feature film, 12 Years a Slave. And I was just riveted by Northup's story, and specifically by his struggle to regain his freedom. So the fact that his freedom was taken away, and then his struggle to regain that. And then shortly after taking that course and reading Northup's narrative, I took another course called American Legal History at Tulane with the woman you see on your screen, the late Judy Schaefer. And Dr. Schaefer's course really kind of made everything click for me. I realized that I could combine my interest in law with history, that I could work on legal history, and specifically that I can also incorporate the history of slavery into that, sort of group of interests. And so I wrote a senior thesis with both Dr. Schaefer and Dr. Randy Sparks, my other advisor, on a Louisiana Supreme Court case from the 1850s. The case was called Ulali versus Long and Mabry, and it involved, it was a freedom suit of a woman named Ulali who sued for her freedom. But in her case, it was not just her freedom she was suing for, but also her children and her grandchildren. About 14 people's lives and freedom depended on the outcome of that case. And so I was just fascinated by this. And when I got to graduate school, and I was at Duke, so, go Duke. I always have to throw that one out on my talks when I get to. I was looking for a dissertation topic, and I heard about this project that was being developed in St. Louis on the freedom suits here in St. Louis. Some of you may know this already, be familiar with this, but because of the notoriety of the Dred Scott case, the St. Louis Circuit Court Historical Records Project received a federal grant to fund the digitization of the suits of enslaved people who sued for freedom in this city. And since I'm imagining much of my audience is familiar with Dred Scott and the Dred Scott case, especially at the Field Museum, given Roswell Field's involvement in the case and helping to bring the Scott's federal suit. But for those of you who are not familiar, I'll just quickly mention Dred and his wife Harriet sued for their freedom in St. Louis initially in 1846. But then they appealed their case. Well, they went to the federal court and they appealed that case all the way to the United States Supreme Court. And in 1857, the US Supreme Court issued an infamous decision declaring that no African Americans could be citizens or have any rights that the white man was bound to respect. That's sort of the language used in that decision. And the case is often listed as one of the contributing factors to the secession crisis in the American Civil War. So Dred and Harriet Scott's a very famous case, very famous example. But what I feel like we don't know a whole lot about are these hundreds of other people who sued for freedom in the same court in St. Louis. And so because of this grant and the start of this project, many of these freedom suits, actually all of the freedom suits that have been found to this point, have been scanned and made available online through the Missouri State Archives, what is now the Missouri State Archives St. Louis branch. And that's what Nicole mentioned. That's where I did a lot of my research. And so that's really what led me to this project. And so I decided to take a look at all of these cases together and to try to learn more about the context for Dred Scott, more about all of these people who aren't famous, who we don't hear that much about, but who also sued for their freedom. And so what I discovered initially, I was interested in sort of the paradox of, a legal case allowing someone to change their personal status. But what I discovered in years of research and book writing is that these cases deal with the relationship between slavery and freedom, but they deal with all kinds of different issues that touch on everything from the history of slavery to the history of law. And so I talk about a range of these topics in my book. I'm not going to be able to cover everything this evening, but I just will touch on a few areas. I'm just hoping to give you a sense really of the rich complexity of these cases, and really also of the humanity involved in the hundreds of enslaved people who bring suits for freedom. Just to give some examples, I will do a lot of storytelling tonight, just because I think the stories are really what's compelling about this research for me. It's the individual people and their stories that really drive me to continue doing this research and doing this work. But before I get into the stories, I'd like to tell you a little bit more about the research involved in the book, and of course, how the cases work. A lot of people want to know, how do people sue? What's the process like? And so the heart of my book is nearly 300 cases of enslaved men, women, and children who sued for freedom in the St. Louis Circuit Court between the 18 teens and 1860. So you're going to see on the screen now a chart that comes from the book that gets at some of the numbers involved in the cases, kind of breaks them down by when they were brought, and also the outcome of the cases if we have that. And so that's really the heart of the research. And then I looked at about 800 state Supreme Court cases from all over the United States. So St. Louis is not exceptional in the number of cases brought. There are lots of these freedom suits in other places around the country. Every state that had slavery had a suit for freedom. And so I wanted to be able to contextualize Missouri and St. Louis within that story. And then I did all kinds of research into the other legal actions involving some of the people in these lawsuits, in the freedom suits in St. Louis. So that's where I spent the bulk of my time in the old, for those of you in St. Louis, the old Globe Democrat building. The big sort of newspaper warehouse is where the archives were for the bulk of the time that I was doing my research. They've since moved to a much nicer space, or a much fancier space, I should say, in more in the heart of town, just down from where the courthouse is, the old courthouse, the historic courthouse. And so what I'm going to talk today comes from all of that research and also some personal papers. I did some work at the Missouri Historical Society right by the park, by Forest Park, and some newspaper research, all of that. So that's sort of the bulk of sort of the basis of the research. So how do the cases work? And I will just, I guess, briefly say from just to explain the chart that you'll see I've got the number of cases, the plaintiffs, that's the enslaved people were suing as plaintiffs, the number of them who are freed, the percentage of them who were freed, the percentage who were not freed, and then those whose outcomes we don't know about. Sorry, my mouse is a little bit sensitive today. I'm afraid it keeps skipping back on me on my images, so bear with me. How do people sue? Well, in Missouri and elsewhere, throughout most of the United States, legislatures passed statutes that allowed people illegally held in slavery to sue for freedom. And so in Missouri, when an enslaved person believed that they were illegally held in slavery, they could approach the court and have an attorney assigned to them. And so this, what you see on your screen now, is an image of the Missouri statute. And I was able to locate these statutes in virtually every state. The only one I couldn't find is North Carolina. And I still am convinced it's there. I just haven't been able to locate it. There were cases from North Carolina, just no statute. So in Missouri, the statute set out the grounds for bringing these suits and the process. And so the enslaved person would come to the court, have an attorney assigned to them, and the state would actually cover the cost of the attorney and cover the cost of the lawsuit if they weren't successful, if they lose their suit for freedom. Now, if they win the case, they won their suit for freedom, the cost would be paid by the people enslaving them illegally, so by their alleged owners. And the fees and rules about the attorneys do differ in different states, but oftentimes the state does provide counsel or provide access to an attorney. Now, in 1845, Missouri does change the law and makes it so that the new statute in 1845 requires enslaved plaintiffs to put up financial resources, what they call security or a bond of security, to guarantee that if they lose their case, someone is going to pay for it. So in other words, after 1845, the state of Missouri is no longer going to cover those costs. And so, as you might imagine, this made it much tougher for people to sue. And so we see far fewer cases in the 15 years after the passage of this law than we see in the previous years before that. And so it is actually in this period after 1845 that Dred Scott sues. And we'll see later on in the talk, I'm going to mention another story where that 1845 change in the law about requiring financial resources becomes really important. But most enslaved people aren't going to have a lot of access to financial resources or not significant resources. And so that really requires them to bring in additional support or to really scrape up a lot of money for an enslaved person to have in order to be able to sue. So it makes it much tougher. So once a person approach the court, they file a petition through their attorney stating why they should be free. What are the grounds for the lawsuit? And so in the St. Louis cases, people sue for a variety of reasons, and I've grouped them roughly into 3 categories. And you can see that in the chart on your screen now. And I'm going to talk about them actually kind of in reverse order. So the first category I want to mention is freedom from birth. And so this includes people like Solomon Northup who are kidnapped, free people who are kidnapped and sold into slavery and then managed to sue to get their freedom back. It also includes people who are descended, if you can prove that you're descended from a free woman, from a free mother, because in the United States, the status of a person as enslaved or free is going to follow the status of the mother. And then also we see some of these suits based on Native American ancestry. So in Missouri and throughout most of the United States, by the 19th century, Native American slavery is outlawed. Of course, it continues surreptitiously, but it's outlawed. And so that can be grounds for a lawsuit and can be successful grounds if they're able to prove that ancestry. The second category, what's listed on here as manumission, involves prior manumission, arrangements for freedom. So this could be someone buying their freedom. And we do know that enslaved people, although they aren't making a lot of money, do manage to do additional work on days where they're not working for their enslaver, and earn money. And this is an incredibly difficult thing to do, but over time, we do know that people are able to save up enough money sometimes to purchase freedom. So that would involve a deed of manumission if they're able to buy their freedom. Sometimes an enslaver would free an enslaved person. So they might agree to free them after a number of years of service, or after they do something considered, especially meritorious, some sort of benevolent reason. And so there are lots of ways that this works, but if you have a deed of manumission, if you've been freed, and then someone threatens your liberty, you can sue for your freedom. And the last category, and really the first one on your screen, is the argument that for residents in a free state or free territory. And this, of course, is the argument that Dred and Harriet Scott make. Both of them spent time in both free territories and free states. In what is today the state of Minnesota, at the time was a territory, and then the state of Illinois as well. And this argument is based on an English case from Great Britain, Somerset versus Stewart, that was decided in 1772. And essentially what this case decides is that once a person lives in a free country or a free state or free territory, they're always going to be free. That freedom attaches, that status attaches to them, and they don't lose that by going back to a place where slavery is legal. So the doctrine states that you're once free, always free. So if you go to Illinois, you're free when you're in Illinois. You cannot then be taken back to Missouri and become a slave. That is what the idea is behind that. And this is by far the most common argument for freedom in the St. Louis cases. We see it also in cases elsewhere, especially cases or states and territories along the border between a slave and free state, because you're just going to have more people crossing over in those places. And so one other thing I'll mention is that sometimes people brought cases that involve multiple arguments for freedom. And that's why those numbers don't add up to that 286 number that you see as the total number of cases. The arguments are sort of, some people could make more than one argument in their case. So after they present the petition and present their argument, the case files are filled with a variety of types of documents. And so some of them are quite short, just a few pages. Some of them are much, much longer. And they include everything from summonses to witnesses to motions that are filed on both sides. The richest cases have witness testimony, so we have longer depositions and testimony about the person, about their case. And then in many of the cases, we also have the outcome of the case, the decision of the court. And so you get a sense here on the screen, the chart you're seeing, that of the total numbers, the different kinds of arguments, and then their percentage of success in terms of winning freedom or not. And so one caveat about these numbers, and so I've only indicated freedom, that the plaintiff was freed in cases where I can say definitively that they were freed. And so a substantial number of cases ended with some language indicating that the person suing, and this is a quote, sort of voluntarily allowed their case to be dismissed. And so I've placed those cases as having unknown outcomes, mostly because in some cases, I've been able to determine that the person made some sort of arrangement for freedom. So the enslaved plaintiff and their attorney come to the court and they say, I'm going to allow my suit to be voluntarily dismissed. But the real reason is that they've agreed maybe to stay on and work for an additional year, and then they're going to be freed or something along those lines. And so there's a lot going on kind of behind the scenes there. So I've placed those in that unknown category, and I'm happy to talk more about the reasons for these different outcomes or the numbers if we have some time at the end for questions. But that's just sort of to give you guys a broad overview of the book and sort of the research involved in the book. And now we'll turn to some of the stories now, the fun part. And so I want to start with the story of a woman named Alcy. Alcy sued for freedom when she was 38 in March 1841. And when she brings this case, she begins a series of legal processes that last more than a decade. So these cases often could drag on for many, many years. And according to her petition, sometime in the late 18 teens, her alleged owner, Robert Cross, gave permission for his son-in-law to take, at the time, 14-year-old Alcy from Kentucky, where they lived, to Illinois to live and work and for his family as a slave. And several witnesses testified to her residence in Illinois. And so when Illinois becomes a state in 1818, the Constitution does prohibit slavery, with one exception that doesn't fit Alcy's circumstances. And so that's the story that Alcy presents to the court, is she's taken to Illinois, and she becomes free by living in Illinois, which is a free territory and then a free state. But some of the witnesses disagreed over the issues in the case. So Cross's son-in-law confirmed Alcy's version of events in his testimony, that he took her to Illinois with Cross's permission, and he says that 5 years after moving there, he sold her to William Campbell to pay off a debt. And William Campbell then takes her back to Kentucky, where he lives. But on the other side of the case, the defense witnesses suggested that Cross's son-in-law took Alcy without Cross's permission, held her in Illinois against Cross's wishes, and sold her to Campbell without any legal claim to ownership. So all of that would make it, would hurt her claim for freedom, because in order to be free once you're in Illinois, you have to be there with permission of your enslaver. And according to one witness, Alcy's alleged owner, Robert Cross, went with this witness to search for her, to look for Alcy, but they waited 5 years to go and look for her. And so they went to Illinois, they went to the home of Cross's son-in-law, and then they had to travel back to Kentucky and go to William Campbell's home to try and demand that Campbell return Alcy to Robert Cross, who was her alleged owner at this point. And so when they get to William Campbell's Kentucky home, he refuses to give Alcy to Cross. And this is a quote from the testimony. They say that he compelled us at the point of arms to desist. And what they mean there is that he's threatening them with a weapon and saying, I'm not going to give Alcy to you. And so once they're facing this threat of deadly force, Cross retreated. He doesn't fight him. He goes home, and he then sues William Campbell for possession of Alcy in a court in Kentucky, and regains possession of her that way. And then years later, Cross takes Alcy, brings Alcy to St. Louis, and sold her to the prominent St. Louis attorney and circuit court judge, Robert Wash. And Wash eventually sold Alcy to William Randolph, who became the defendant in her suit for freedom. And so Alcy's story really illuminates several key features of how St. Louis's freedom suits functioned. And the process of these cases and their outcomes often relied on interpersonal relationships and local influences. Focusing on legal cases as processes really shows how legal authority operated in the lives of ordinary people, which involved a combination of experiences in court, along with a lot of informal conversations and negotiations, debates happening outside of the court. In Alcy's example, one witness in her case elaborated on his personal problems with Judge Robert Wash, the judge who bought Alcy in St. Louis and then sold her to the defendant of her freedom suit. And this witness was actually bitter and upset with Robert Wash because he had lost some of his own enslaved human property in freedom suits where Judge Wash was the judge in those cases. And so this witness blamed Judge Wash, testifying that he was sorry to know such a man whose decisions against him were neither legal nor constitutional. And so the witness even offered to give $100 to help Alcy win her freedom, hoping to force Judge Wash to lose his investment in Alcy because, and this is a quote, he said, he very much dislikes the man. So personal conflicts like this one seeped into the decision making in freedom suits, really connecting a whole web of people who each brought their own unique set of motivations to these cases. And in this instance, even an enslaver and a defendant in a handful of freedom suits offers to give a substantial sum of money, $100, to help an enslaved woman prosecute her case because he dislikes someone who's involved in her case and as a way to get back at him. And so we can kind of see how these other personal conflicts are influencing the trajectory of Alcy's case. And so Alcy's case illustrates several of the points of my book. So we're going to kind of keep coming back to it throughout the talk. But her case spawned additional litigation and struggles. Whenever there's financial resources involved, we're going to see these kind of additional cases. So Alcy does win her freedom in 1843, and she wins an appeal to the Missouri Supreme Court in 1844. And shortly after that initial verdict for Alcy's freedom, the defendant, William Randolph, sued Robert Wash for selling Alcy. And so this is the part of the story that I find maybe most interesting and a little bit surprising. Judge Wash has been in freedom suits. He's been in, obviously in courtrooms. He's a judge, but he fails to appear in court when it comes to trial. And the court then decides for William Randolph by default, just because Robert Wash doesn't show up. And then Wash appeals that decision twice to the Missouri Supreme Court after the St. Louis Circuit Court refused to reinstate his case. So he loses essentially the money that he paid when he bought Alcy from Robert Cross, and he has to pay that money to William Randolph. So freedom suits held substantial financial repercussions for defendants who lost valuable human property. Each freed plaintiff left a trail of slave traders and slave buyers desperate to pass the buck and avoid the loss. And as Wash learned, some enslavers managed to dodge their responsibility by pursuing additional legal recourse against people earlier buyers and sellers of someone who was an illegally free person like Alcy. And so after Wash loses his appeals, he actually tries to institute a legal process against Robert Cross, who sold Alcy to him. He does things like he hires someone in Illinois and in Kentucky to investigate how much did Robert Cross really know about Alcy going to Illinois. And he keeps trying to find evidence, but he's never able to find enough evidence to bring a case. So he doesn't actually sue Robert Cross, but I do have letters that he wrote about the case to people in Illinois, trying to dig up dirt basically on Robert Cross. So again, we see how William Randolph sues Robert Wash, who then tries to sue Robert Cross. So it's kind of this sort of ripple effect out in terms of trying to figure out who's going to be the one losing the financial investment here. And so really what Alcy's lawsuit and so many of these cases speak to, in my mind, is what I call the legal culture of slavery in a border city like St. Louis. And so the term legal culture, and sorry, this is my one kind of professor definition slide. I know it's a little text heavy, but just want to make it really clear. The term legal culture refers to the constellation of attitudes and experiences concerning law in a particular time and place. So this is going to be separate from formal legal institutions like statutes and court proceedings, though these institutions certainly influence how people understood law and legal authority. But legal culture is really about how communities discuss law, think about law, and how people's views on laws really as an institution shape their everyday lives and practices. I always tell my students that legal culture is about when you don't necessarily see a police officer when you're speeding, but you slow down anyway. You remember the last time you might have been pulled over, seen someone pulled over, and it influences your behavior. Or it's, when you're talking about it, talking about law in some context, that's what is really about legal culture is about. And within that, within the broader term of legal culture is what scholars refer to as legal consciousness. And legal consciousness is about an individual's view of the law, their experience of law, and the considerations a person makes before approaching the legal system for assistance. And so all of this really comes out of the day-to-day workings of local communities. So in the example of freedom suits, it's not only the cases themselves that are generating this legal culture of slavery, but it's also the practices that happen before, during, and after the cases. And so Alcy's story really demonstrates how freedom suits are these kind of like hubs around which we see a whole bunch of different interconnected legal actions, conversations, negotiations, attempts at legal actions. And so these webs really of interpersonal or of personal interests, violence in some instances, some examples, power, deception, all really influence each person's personal battle over slavery in the court. And so for my research, the legal culture of slavery refers to the areas of law and legal practice related to enslaved individuals. Enslaved men, women, and children encountered the law in their daily lives through legal regulations and restrictions on their behavior. So things like property clauses that might result in transfer after an enslaver died, and occasionally through lawsuits directly involving them. So, but you don't have to have a lawsuit to have the law really interacting with enslaved people's lives. So for example, enslaved individuals knew about limits placed on their mobility when they requested a pass or encountered a slave patrol who could punish them just for being off of their plantation or farm without permission. And you see here on your screen a couple of examples of slave patrols badges. These are obvious. I think with these images, you can kind of see how the slave patrol is sort of the precursor to the police force, right? And so they would know that the authority of law behind these, usually it was men. And so these same enslaved captives would also recognize the law's role when their enslaver died, potentially forcing them to either move to a relative's house or even face sale on the auction block, the other image you see there. And given these dire consequences, literally life and death consequences, physical violence as a consequence, it should come as little surprise that enslaved people realized that knowledge of the law was paramount for their survival within the system of American slavery, and that they sometimes managed to make the law work to their advantage. And enslaved men, women, and children are really central players in these processes that in the process of helping to create legal culture in St. Louis and elsewhere. And so in St. Louis, the legal culture of slavery emerged from a multitude of voices and processes. And Alcy's case really illustrates this through multiple and sometimes competing conversations it generated about the law of slavery. So for example, Randolph's case against Robert Wash, Wash's letters to Illinois about Alcy's freedom suit, the financial ramifications here, Alcy's witness who came and had a personal grudge against Judge Wash. All of this kind of underscore the wide range of perspectives and reactions that Alcy's lawsuit invoked. And by contrast, when we think about individual legal consciousness, we think about Alcy here, that really refers to the manner in which she learned about law and her right to sue for freedom, the kinds of considerations she took before bringing a lawsuit. And we do know that this is a dangerous prospect to bring a suit for freedom. And some people faced, not only physical violence, but the threat of sale away from their families, away from St. Louis, if they brought one of these cases. So it took some consideration for sure before bringing these suits. And also things like how her experience in her case affected her understanding of law and legal authority. So these are just a few examples. And I talk about a lot of that more in the book in terms of legal consciousness versus legal culture. The second major point of the book I want to highlight today is the issue of mobility. Like legal culture, the discussion of mobility in the book really touches on broader issues of how people's ability to travel affected interstate relationships and legal decision making in an era where we see increasingly available transportation opportunities, steamboats, the beginnings of railroads, and this includes opportunities for movement for enslaved and free people of African descent. And so Alcy's case also illustrates this mobility. She moves from Kentucky to Illinois and then to St. Louis, and that's what allows her both the grounds to sue for freedom and then the opportunity to find a lawyer and sue. But I want to talk now about another example of mobility and its repercussions and a different case, which is the story of Thornton Kinney. And so Kinney was born in Virginia to a Native American descended mother, born free, I should mention, in Virginia. And when he turned 21, he obtained a copy of his free papers. These are, physical papers proving that he was a free man. And like many people in this era, in the antebellum years, he took this proof of his free status and joined a wave of westward migration of people leaving the eastern seaboard for opportunities to work in the West. And for Kinney, that meant work on steamboats, traveling the Mississippi and Ohio rivers. He eventually met a member of the American Colonization Society during a stopover in St. Louis. And this is a group of people in the 19th century who believed that essentially that people of African descent and people of European descent couldn't possibly live together in society. And so they needed to try to help people of African descent, quote, return to Africa. Of course, we know many of these people were not born in Africa. They were born in the United States. But that's the idea, is that they founded a colony in Liberia, and they were helping to kind of raise money and encourage people, especially free Black people, to return, quotes there, to Africa. And so Kinney goes to Liberia. He stayed there only 5 years, but when he left, he planned to leave permanently. And so while he was there, he threw away his free papers. He didn't think he would need them anymore. And also he testifies in his petition, he says that the constant traveling that, you can imagine working on steamboats, and that they would get wet and would have all kinds of damage. And he says that they were so worn and mutilated that no one could decipher them. So he threw them away. But then when he comes back to the United States, he recognizes that his skin color leaves him vulnerable to enslavement. And so he takes immediate steps to protect his free status by approaching 2 separate legal arenas to secure his status. So when he comes back, he goes to a court in Louisville, Kentucky, and files a permit proving his freedom. He does the same thing in New Orleans with a notary public in New Orleans. And we see through that how free people of African descent really rely on the strength of the legal system, and especially its written documents, its legal offices, that sort of thing, to protect their status, especially when traveling across borders throughout the slaveholding South. After Kinney secured legal documentation, he goes back to working as a cook and steward on the Mississippi River. And while he's doing that, a steamboat captain claimed Kinney was his slave, that he owned him, had Kinney imprisoned in New Orleans, and offered him for sale by a slave trader. And the trader's numerous attempts to sell Kinney could not succeed. And this is a quote from the case: for the reason that he would always tell anyone who spoke about buying him that he was free. So in other words, he kind of constantly undermined the trader's efforts to sell him. And Kinney made a daring escape from the window of the slave pen and resumed his business, goes back to working on steamboats. He moves to St. Louis, marries a free woman in St. Louis, and kind of goes on with his life. And for a time, he's able to do that. But the steamboat captain eventually does catch up with him, has him arrested in St. Louis as a fugitive slave. Kinney then sued for freedom in the St. Louis Circuit Court in November of 1853. And 2 years later, on December 21st of 1855, despite his many contacts and many efforts to protect his freedom, the court dismissed Kinney's freedom suit because he failed to provide money to secure the costs. Remember, I said that that change in the law requiring an enslaved person to provide money to secure the costs was going to be important for later on. Well, that's the Kinney's case. He's not able to provide those financial resources, and so they dismiss his case. And I don't know what happened to Kinney. I looked very hard to find whether or not he becomes free some other way. I can only hope that he lived to see emancipation a decade after his case was dismissed. But Kinney's story really illustrates kind of this mobility that affected not only enslaved people, but also affected the law, because when he crosses these different jurisdictions, his case raises a host of legal questions. And courts are really forced to decide these kinds of issues, kind of highlighting the differences between different courts and the ways that these courts had to handle these questions. And I think it highlights the importance of a border region like Missouri, where you see, and like St. Louis, where you see lots of crossing of these borders and the consequences of that. The last point I want to draw attention to is really how there are many people contributing to this developing legal culture. I already mentioned in Alcy's case the ways in which enslaved people and other people are interacting with these cases. But we also see lawyers, judges, the broader community. All of these people are involved in these cases in a number of ways. And so we typically think of a lawsuit as a two-sided contest, right? You've got a plaintiff and a defendant, but these cases I think illustrate that there's a whole range of people involved. And so I'm just going to close with a few quick stories to illustrate different people's involvement. And the first one here comes from the only enslaved person who wrote about her experiences in a freedom suit years later in her memoir, published in the late 19th century. And that's Lucy Delaney, who you see on your screen now. So I'm going to read this section to do justice to Lucy Delaney's words and describe what it was like to sit in the courtroom. So as young Lucy Delaney waited for the judge to announce her fate, she trembled in her seat. She later described the scene as a bright, sunny day, a day which the happy and carefree would drink in with a keen sense of enjoyment. But she said, my heart was full of bitterness. Lucy recognized the gravity of her situation. Within minutes, the judge would announce the jury's decision and declare her either legally free or permanently enslaved. I could not tell one person from another, Lucy wrote. Friends and foes were as one, and vainly did I try to distinguish them. I felt dazed, as if I were no longer myself. Lucy sat bewildered as the trial resumed, and her lawyer made an impassioned and insistent plea for the court to release her. And the judge does agree to release her after reading the jury's verdict. And in response, the defense attorney leaps from his seat to protest and demand that Lucy be returned to jail until he could, basically appeal the decision. But Lucy's attorney, at least according to her account, successfully defended her right to liberty. And she expressed some sense of the joy she felt at that time. Oh, the overflowing thankfulness of my grateful heart at that moment. Who could picture it? None but the good God above us. I could have kissed the feet of my deliverers, but I was too full to express my thanks. Lucy's triumph followed nearly 17 months of time in jail awaiting her trial, as well as, of course, years of contemplating how to escape her enslaver and a lifetime of abuse in slavery. But one of her deliverers in Lucy's telling was her attorney, Edward Bates, who you see here on the screen. Some of you may recognize Bates. He later becomes Abraham Lincoln's attorney general during the Civil War. And so enslaved plaintiffs take a difficult step by initiating suits for freedom, but they ultimately rely on the attorneys assigned to them to win. So really a lawyer's role here could make or break the person's case. Sometimes lawyers just didn't show up in court. Sometimes they went to extraordinary lengths and personal expense even to travel and take depositions and find evidence to prove the case for their enslaved plaintiffs. So there's a lot of flexibility, and we see a whole range of lawyers' efforts or lack thereof. And so they're really an invaluable part of the process and the contributors to these cases. And I'm happy to talk more about lawyers in the Q&A, but I think I might be running low on time, so I'm going to move on. But it's just want to make the point that lawyers are really about one of the groups of people who help contribute to this. And then finally, like the attorneys, we see local communities influencing the cases in a variety of ways. Local communities gave testimony in court, participated on juries, sometimes provided financial support to enslaved plaintiffs, especially after that 1845 law. And we know that, for instance, with Dred and Harriet Scott, that it was community members who knew the Scott family who helped them by putting up the bond for them to bring a suit. And so in antebellum America, community relations and a person's reputation mattered. And the support of communities of relations could help enslaved plaintiffs win their freedom or prevent them from doing that. And so I feel like testimony is really the best example of the public's involvement in freedom suits. And we see this as a lot of the evidence for the cases and the actual case files. And so I'm just going to give you two quick examples of how testimony affects the cases. And George Johnson brought the first of his two freedom suits in 1852. And he sues for freedom based on the fact that he was born free in Pennsylvania and then was taken and wrongfully or illegally enslaved. He moved to Missouri and lived as free for 8 years before he's again, like Kinney, working on steamboats before someone claims him as a slave. And Johnson drew on his relationships in Pennsylvania to make his claim for freedom. One witness testified that he first knew Johnson in Pennsylvania when he was, quote, considerably smaller, meaning he's a child at that time, and that they played together when they were children. And this is a quote as well, that he was always under the impression that he was free, of course. Another witness testified that his impression was that he was a free man because he acted for himself. And so George Johnson relied on the testimony of the men and women he worked or he knew in Pennsylvania, and as well as some people that knew him working on the Mississippi River boats to bolster his claim for freedom. And what's interesting about this case is that the focus of the depositions is not on Johnson's residence in Pennsylvania, a free state, which was a common argument for freedom. Rather, the testimony is focused on the individual's impressions, the impressions of the community as to whether or not Johnson is going to be free. So while we see testimony can benefit a plaintiff, as in the case of George Johnson, we also see that defendants, enslavers, are also using testimony to try to win their cases. And so the other example I want to share with you is George Ralph's case against Thompson Ficklin from 1828. And in this case, the defendant uses a witness's testimony, a former enslaver of George Ralph, to impugn his character and claim in his morals as a way to kind of hurt his efforts. And so this former owner of George Ralph stated that, and this is a quote, after he had made a second attempt to commit murder on the family of this deponent, meaning the witness drove the said George from his house and declined having anything farther to do with him. And the witness then explains the attacks that George Ralph made on his family. And he says, George advanced into the room where the deponent and some company were sitting with an arm elevated in a striking position, meaning he would kill the rascal. This deponent sprung towards him and with difficulty avoided the blow. And 3 years later, the witness described a second attack when Ralph threatened another slave with a gun and then threatened to shoot the witness when he tried to intervene. And so after the second attack, it's unclear really why it took two attempted murders, according to this witness. The witness says he feared for his safety and he sold Ralph to a slave trader. But the point is, by relating these kinds of violent episodes to the court, the witness hoped to impugn Ralph's character and prevent him from winning his freedom. And so we see here how testimony by community really shows in both of these cases that more is at stake here than the determination of a single person's freedom. These cases helped create and shape precedents and a legal culture of slavery that would help kind of communities define and understand personal status and who is going to fit in what category. So to close, determining the future of slavery in the United States was really the central question of the antebellum era. Although freedom suits were disputes over the personal status of an individual enslaved plaintiff, or sometimes a group of plaintiffs, the various men, women, and children who participated in these cases contributed to foundational debates about the role of African Americans, enslaved and free, in local communities and in the nation. Freedom suits occurred throughout the slaveholding states and prior to the American Revolution in the colonies as well, making these cases, while not common occurrences, certainly a well-known aspect of the law of slavery. As the initiators of these lawsuits, enslaved plaintiffs shaped the content and direction of these discussions, making their mark on the political landscape. And their lives, these are people whose lives left few traces in the historical records. And with the exception of Dred Scott, they're largely absent from conventional histories of this era. And, that's part of the reason I'm doing this, actually, that I wrote this book, is that I really hope to give life to these stories and to share their stories. And really, I think the stories that emerge from the case file speak to the networks of interactions that took place inside and outside of the courtroom. And through these efforts, enslaved plaintiffs and their supporters managed to wrestle small concessions from enslavers and to set precedents for future litigants. Thank you. I'm happy to take any questions that you have at this time. I don't know how we're doing the questions.
Okay. Can you see me?
Yes, I do.
Excellent. Thank you, Dr. Kennington, for that wonderful presentation. And we do have some questions. And if anybody watching the live feed has further questions, you can just leave them in the comments. So our first question comes from Dave Brown, and he asks, is the Dred Scott case the only one that went all the way to the SCOTUS?
It is not. There is a case from the 1830s that also was appealed all the way to the Supreme Court. And that case dealt specifically with members of the military and whether a member of the military could, if they were stationed, for example, if an enslaver who was in the military was stationed in a free state or free territory, were they able to take an enslaved person to that free territory, or did they risk losing that person if they took them with them? And so that was another St. Louis case that was appealed all the way to the SCOTUS, as we call it.
Okay, and then that would have been one of the bases then for the Dred Scott case later.
Yes, absolutely. It does tie into the Dred Scott case.
Okay. And another question we have is, how were cases in St. Louis handled differently, or how are they differently than maybe cases in Louisville or in New Orleans?
Well, I think, Louisville is actually fairly similar. A lot of the border states, the sort of, Kentucky, Virginia, a lot of the cases that I've seen, DC, there's a big group of cases that also has been recently digitized in Washington, DC. A lot of those cases have very similar issues, a lot of crossing over borders and that kind of thing. But what we see with New Orleans is that because it's not as close to a free state or free territory, you do see some of those kinds of arguments being made for people who travel from New Orleans to France and come back. But you're going to see many more cases brought on some of the other grounds that I mentioned, things like people like Solomon Northup, who was free and then kidnapped and sold into slavery. cases where someone had been freed previously and then were later claimed as a slave. Cases involving disputes over wills. There's a whole section in my book about will disputes when an enslaver dies and they give the person freedom in their will, whether or not the court is going to honor that. So the types of cases that are brought are different. And the laws about attorneys also are a bit different. And I believe it's been a while since I reviewed this, but I believe it's South Carolina that has in their statute essentially a penalty for the lawyer if the case is not successful, to discourage lawyers, I guess, from bringing frivolous lawsuits. So there are some differences in terms of sort of the nuts and bolts and how they worked. But I think the biggest difference that I focused on was really the different kinds of cases that show up, the different kinds of arguments.
Okay. And then we have another question here from Facebook. Can you speak about the Fugitive Slave Law of 1847 and how late did the law apply?
So the main fugitive slave law that I'm familiar with is a little bit later than that, in 1850, but I'm assuming that's the one that they're talking about. And that does make it much harder for people to sue for freedom. I don't see that. I'll be honest, I don't see that law actually interacting a lot with the St. Louis cases. But we do know that with that law, one of the restrictions is that if a person is captured as a fugitive slave, that they're not really able to present their case for freedom. They're not really able to present evidence of their status. They aren't given that kind of what we would today call due process of law. And so that statute actually circumvents some of the constitutional rights of people in those situations. But I don't see a lot of those. I don't really see that law kind of interacting that much with the freedom suits in St. Louis. The one thing I will say is that sometimes a way around that is that you'll see people file what's called a habeas corpus petition, which essentially just says, and those still exist today. Basically, if you're wrongfully imprisoned, if you have been detained and you don't know why, you can bring a habeas corpus action demanding basically that the court either release you or explain or justify holding you. And so we do sometimes see those in St. Louis, and I suspect that those are people that are trying to get around that Fugitive Slave Act.
Okay. Was there any particular case that wasn't mentioned in the presentation that kind of stuck with you or that you really found yourself interested in?
Oh, there's so many different cases. I think the one that stuck with me the most, and it is really a tragic one, is and I've this has been several years, so I forget the woman's name. Oh no, I'm sorry. It just came back to me, Dorinda. And she brings a suit for her freedom. Her lawyer comes to court and says, look, she's in danger. Her enslaver, the defendant in the case, is going to take her out of St. Louis, is going to try to prevent her from bringing her case by sending her away. And there's actually a letter from that's written in, I believe it's written in Memphis by someone who's trying to help her, writes back to the court in St. Louis to explain that she's been sold away, that she's been sent to, that she's in Memphis at that moment, but she'd been sold to a slave trader. And the court dismissed her case because she doesn't show up in court. And that's sort of the end of her story. But to me, that is the real danger for enslaved people bringing these cases, is that, they need protection, and sometimes they were protected. And I use that term protected somewhat lightly because their protection was often to be put in jail while their case was going. So I mentioned that with Lucy Delaney. But Dorinda's story, in addition to Kinney, there's just a few of them that I really wish I knew what happened to the people after they disappear from the record. But she's one that really stuck with me.
Okay. And then Dred, he was placed under, I guess, the protection of the sheriff, if I'm remembering correctly. Was that kind of unusual for the time, or was that essentially
No,
the
I mean,
way?
that's part of their job essentially, and sometimes that involved the person being held in the jail, and sometimes not, but usually they were in the jail. And I have a little section in the book on the St. Louis jail from the antebellum period. So if you want to hear, if you think prison conditions, are bad, they were always bad. And the jail, there are these reports that would be presented to the court, actually to the circuit court, on the status of the jail and the condition of the jail. It was not a place you wanted to spend any length of time, and many of these cases do drag on for months and months and sometimes years. And so being held in jail, or in Dred's case, if the sheriff is protecting him and his family, it did involve a certain amount of risk as well.
Okay, and then I have one last question for you, and we'll see if anyone also on Facebook has any more questions. But was there any particular case that was easier to win, whether it be freedom at birth or being in the territories?
Yeah, actually, I mean, if you look, I guess I can go back if I won't give anybody like whiplash by going back here to the numbers. There we go. You'll see that the largest percentage of people who are successful are the people that argue freedom from birth. And a lot of times that's because they have greater documentation of their freedom, and that allowed them to be more successful. So if you were living as a free person and you're kidnapped and sold into slavery, it's still not easy. We still have less than half of people winning those cases, but that one's the one that's the most successful overall.
Okay, excellent. And I'm not seeing any more questions. Well, this has been great. Thank you so much for joining us. And if anyone is interested in purchasing in the Shadow of Dred Scott, and the rest of the very long titles escaping me right now.
Sorry, it's okay.
But if anyone is interested in purchasing, you can find the link to Amazon in the comments here on the video, as well as on the main discussion page for this event. So thank you so much for joining us tonight. I'm really glad. Oh, we had one more question just come through. How long of a period of time did they have to be in a free state? What if they were just traveling across Indiana, for example?
That's a very good question. And that does change over the time period that I looked at for these cases. So in the earlier years, people would bring cases based on just kind of traveling through. And then eventually it is sort of established that you have to, that the enslaver, rather, who's taken you to these free states or free territories, you have to be able to prove that they intended to reside there. So that could mean like the length of time that they stay there. One case talks about the enslaver says, yeah, we were there 6 months, but we never unpacked our wagon. So we were never really meaning to stay. And so we see that all of this testimony about whether or not that person was actually trying to make that place their home, or whether they were just visiting, because in the antebellum period, visits would sometimes last weeks or months because of the difficulty of travel, that sort of thing. So it wasn't unusual for people to be gone for a length of time. Now, there are some states who came up with a specific period of time, like if you're there 90 days, you're free. But with the St. Louis cases, they never establish a firm length of time. The standard they use is whether or not that person intended to make that place their home, or whether they're just traveling or passing through. And so that's where the testimony gets really interesting about how people try to get around looking like they live somewhere by not unpacking a wagon, for example.
Okay, well, yay. Well, I mean, again, thank you for joining us tonight. And I think, yep, that we're gonna call out on the questions.
Okay, well, I'm available by email. My last name at auburn.edu is my email. If anyone has any further questions that I didn't answer tonight, I'd be happy to respond that way.
Excellent. And they can find your book on Amazon and also at the
University of Georgia Press has it as well. Really, any bookseller. I shouldn't say any, because probably most local booksellers aren't going to have it, but you should be able to order it through your local bookseller as well.
Okay, excellent. Well, thank you so much again, and thank you for joining us. We really enjoyed having you and this great presentation and talk. So yeah, and we hope that everyone else will join us again in the future for our upcoming other speaker series and author talks here on Facebook Live. And if you get the chance, the museum is back open for tours. You can call us ahead of time to schedule a tour. We are taking measures to make sure that everyone is socially distanced and that sanitation is occurring. So thank you again, and we hope to talk to you again soon and hope to see everyone back at the museum soon. So.